Disney's beloved 2016 animated film Moana is now at the center of a legal battle as writer and animator Buck Woodall claims that the movie was based on his own original work, Bucky the Surfer Boy. Woodall has taken Disney to court, alleging that his story, which revolves around a young teenager's adventure in the Pacific, was used as the foundation for Moana without his permission. He is now seeking $10 billion in damages, arguing that Disney profited off his ideas without giving him credit. According to Woodall, he wrote Bucky the Surfer Boy years before Moana and submitted it to Jenny Markick, a former development director at Mandeville Films, between 2003 and 2008. Woodall believes that his script, which involved a young hero embarking on a quest over the ocean, encountering a demigod with a magical hook, and discovering their ancestral heritage, made its way into Disney's creative process. He claims that the similarities between his script and Moana are too striking to be a coincidence. The lawsuit has sparked debate in Hollywood about the protection of creative works and the influence of independent writers on major studio productions. Woodall argues that his script featured a rebellious teen protagonist who, against parental advice, sets out on a journey filled with mystical elements tied to Polynesian culture. The film Moana follows a similar storyline, with the titular character defying her father's wishes to sail beyond the reef, meeting the shape-shifting demigod Maui, who wields a magical fishhook, and ultimately restoring balance to her homeland. Disney, however, has strongly denied the allegations. The company maintains that Moana was developed entirely in-house through a lengthy research process involving experts in Polynesian history and mythology. They argue that no one involved in Moana's creation had access to Woodall's work. Co-director John Musker even testified that the film was an original production and dismissed the plagiarism claims as baseless. The case is currently being heard in a federal court in Los Angeles, where a judge and jury will determine whether Disney had access to Woodall's work and if substantial similarities exist between the two stories. If Woodall can prove that his script was improperly used, it could set a major precedent for intellectual property cases in the entertainment industry. However, if Disney successfully defends itself, it would reaffirm the company's long-standing position that Moana was a product of their own creative vision. This lawsuit has drawn attention from writers and animators who fear that large studios may take inspiration from independent creators without giving credit. The outcome of this case could influence how studios handle outside submissions and how copyright laws protect individual creators from unauthorized use of their work. As the trial unfolds, industry professionals and fans alike are watching closely to see whether Moana will be proven as an original masterpiece or a product of borrowed ideas.